Hello, everyone, and thank you for joining me today for the 5 reasons to have an estate plan that are more important than the money saved. My name is Lynn St. Louis, and I am an estate planning and elder law attorney at ELG Estate Planning, where we empower life goals. We will be talking about estate planning and the reasons that an estate plan is important that is beyond saving and protecting money. And we serve clients who are in Washington and Idaho, but today's topic is broad enough that even if you are in a different state, you might get some benefit from our discussion about things that are important to think about with your estate plan beyond the money that's saved. Well, commonly, when people think about an estate plan, they think about money, rightly so. Estate planning is about money. It is about protecting money, making sure your money goes where you want it to go when you are gone, protecting your beneficiaries with the money that you're giving them. So there is a lot to estate planning that has to do with money. But at the same time, there's a lot about an estate plan that has nothing to do with money, or money isn't the primary factor. Really, the positive effect on you and on your life, your family's life, is what we're going to be talking about when you have the right estate plan. But to be clear, an estate plan is always going to in some way be about money. So before we get into the 5 very important reasons to have how you're impacted by a good estate plan, I do want to give a little bit of time to talking about money and the money that would be saved by a good estate plan. For example, so we've established having an estate plan protects you, protects money, protects your family. How? In what ways? And I just want to get this out of the way before we move beyond the money piece of this. In a good estate plan, make sure that taxes, estate taxes, and other taxes are minimized or eliminated. Without a good estate plan, if you have a taxable estate, which in Washington is just a little over 2 million, you may be paying tens, if not hundreds of thousands of dollars in unnecessary estate taxes. A good estate plan will make sure that doesn't happen. A good estate plan secures funds so that no one who you don't want to get those funds, especially the government, has any right to those funds. So securing the funds for those that you want to receive them, those are called beneficiaries. That is an important part of a good estate plan. Also, making sure that no creditors get your estate who don't have a legitimate right to be repaid, and that they filed an appropriate claim against your estate, and that there are no exceptions to them getting paid. And believe me, there are a lot of exceptions that can apply such that creditors' claims will not be paid in an estate matter. Making sure, another money issue is making sure that there's something left to pass to your spouse so that they are not left impoverished, even in the face of long-term care, expensive long-term care. That's part of one of the money benefits of having a good estate plan. And of course, making sure that eligibility for government benefits is not interfered with, and that government benefits that your beneficiary is entitled to will continue. That's another part, a money part of having a good estate plan. Also, making sure that if your children are inheriting from you, that your money goes to the children and not to their divorcing spouse. That's all done through a good estate plan. And speaking of kids, there is something called unintentional disinheritance. And that happens if you remarry later in life and your estate plan is not set up to protect your kids from a prior marriage. And if they end up with nothing, Oftentimes that's called an unintentional disinheritance. So making sure your money goes to your kids, if that's what you want, is also a good part of having an estate plan. So yes, a lot about estate planning is about protecting money, preserving money, making sure that whomever your beneficiaries are get the money and that their lives are not negatively impacted by having the money. I wanted to get that out of the way first. Yeah, there's a lot of reasons money-wise to have a good estate plan. Let's talk about that personal, emotional, positive impact on your life. 5 really important reasons for you, not so much related to money, but just for you to have a good estate plan. We at ELG Estate Planning are about empowering life goals. We want to make sure that our clients, and then through education, people are aware of what they can do to empower their life goals. A big part of that, and this is the number 1 on our 5 reasons that are more important than the money, is keep control over your life. To the extent you can keep control over your life, we want to make sure that you have the right legal documents in place so that you can do that. When somebody is fully in charge of their, finances and their affairs and their health, they're not even thinking about this. But part of being an estate planning and elder law attorney is thinking about the what ifs. This happens in the future, or that happens in the future, this or that being possible incapacity. So keep control over your life, and I'll tell you how you can do it. But when we're talking about how to keep control over your life, number 1, make sure your wishes are known. And when I say known, make sure they're in writing. Make sure your wishes are followed, so they're not ignored. How do you do that? You do it through the clear written instructions in your legal documents we're going to be talking about, and through appointing someone that you trust. This is the key to not just having your wishes in writing, but appoint somebody that you trust with your money and your life. Somebody that you know you can count on no matter what. They will carry out your wishes. That is such an important part of making sure that you keep control over your life, even if actually you've lost the ability to manage your affairs because of incapacity. Why this is so important is that if you don't have the right estate planning documents in place to keep control in your life, then what happens is that the state will step in through a court-ordered guardianship and conservatorship, and that is a very public declaration that you have lost capacity, that somebody else is in charge, somebody maybe you've never even met before is appointed as your guardian, as your conservator. All these very personal matters are written down and recorded in the court file, your personal care plan, your finances, everything to do with your life becomes a matter that's part of a court record with the state and with somebody being appointed your guardian. That is a complete and utter loss of control. Even if you have incapacity, you don't ever want to be in a situation where you're in a court-ordered proceeding like that. No, we can't always keep control of our life in that we can't always make sure that we don't lose capacity. Strokes happen, dementia happens, these things happen, but do your best to keep control over your affairs the best you can. Don't let the court step in. How do you accomplish that control? How do you maintain as much control as you can in your life? Through the living documents that are part of your estate plan. Those living documents are your durable powers of attorney for finances and for health. It's in those documents where you say what authority are you giving to this trusted individual that you are appointing to be your voice and to carry out your financial and your personal healthcare affairs. The person that you're appointing is called your attorney in fact. Sometimes they're called an agent, and sometimes they're called a healthcare agent. In slang, people call this person my POA. they're not your power. They're appointed under your durable power of attorney. Calling them your POA is just fine. It clearly communicates this is the person who will be my voice if I can't speak for myself. Why it's so important to have that durable power of attorney is that ensures that your voice will be heard, that you have thought through with the help of your attorney what authority you are going to be giving under your durable power of attorney to that appointed agent whom you trust. With that document in place, the durable power of attorney, you should not ever be subject to a court-ordered guardianship yourself if you were to lose capacity. It's probably the most important thing you can do for yourself to make sure that, nobody wants to think of a loss of control over their life. But nonetheless, I have to tell you, as lawyers, we plan for what if this happens? Have a good durable power of attorney in place. So if that unthinkable thing does happen, at least somebody that you really trust will step up and take care of things for you. And it won't be the court messing with your business. One of the things that I think that goes to keep control over your life is if you're a single person, everything I said is true. If you're a married person, I said, if you have a good durable power of attorney, you can keep the court out of your life. Well, that's maybe true, maybe not true. Let me tell you why. If you're married, your spouse also needs to have a good durable power of attorney in place, because if your spouse loses capacity, if they lose the ability to manage their own affairs, you might think, because I'm married to that person now, I can manage their affairs, especially because we own our home together. We're both on title to our home. Therefore, I can be in charge, right? Wrong. Joint titling of an asset does not necessarily mean you can control the other owner's ownership of that asset. And you can't control your incapacitated spouse's ownership of your home. So this is a very unpleasant surprise for spouses, especially ones that haven't paid any attention or much attention to their estate plan, and one of them becomes incapacitated. So let me tell you what happens when a spouse loses capacity and they didn't have any durable power of attorney. What happens is there will be a court-ordered guardianship and conservatorship over your spouse, over their person, and over their finances, over their assets, over everything in their life. Now, you as a spouse may be appointed as their guardian and their conservator, or perhaps you won't be. It could be somebody else who will be appointed. Imagine the situation where maybe it's a blended family, second marriage, children from another marriage, assets from the earlier marriage. That incapacitated spouse, they may have other family members who say, oh, I want to be the guardian. I want to be the conservator. I want to be in charge of dad's affairs, for example. And you are the spouse and you're saying, no, I want to be in charge. And you might not be appointed. It's not uncommon that you won't be appointed. What does that mean? That means with respect to not just your spouse's affairs, but yours too, because your and your spouse's assets can be blended together. You have joint accounts, a joint house, joint all sorts of things. And now you and how you spend your money and what you do with your money, you're not free to do it. The court has to give you permission to do certain things. To sell the house? No, you can't do that. It's your house, but it's also your incapacitated spouse's house. So you can't sell your house without a court order and without the guardian or conservator being on board. So when I'm talking about keep control over your life, if you are married, it is very important that not just you, but your spouse have a durable power of attorney for finances. Now, typically spouses appoint each other, but that doesn't have to be the case. The spouse could appoint, a child from a prior marriage, and there are problems with that. It's much easier if you can trust each other enough that you can be in charge of your own finances or the other person's finances. But that is one of the key ways that you can keep control over your life if something bad happens to your spouse and they lose capacity. Don't let their finances, their personal care, which impacts your life, which means your finances, be in a court setting with the court making decisions about what you can do. So durable powers of attorney, not just for yourself, but also for your spouse. They need to have one as well. And it should be a good one. I just gave you an example of what happens if your spouse doesn't have any power of attorney. But what if their power of attorney was prepared either on their own or by an attorney who was not experienced in estate planning and particularly in elder law? What happens then if it is a bad power of attorney? Let's not say bad, an inadequate power of attorney. Let me give you an example of a situation that I'm familiar with. In this particular situation, what happened was it was a remarriage, and both spouses did get durable powers of attorney, but the husband wanted to make sure that his new spouse didn't have too much access to all of his finances. So he appointed her as well as his adult son from a prior marriage as co-attorneys. In fact, co meaning in the situation, they weren't empowered to act independently. They had to agree on everything. And they agreed on nothing. Because of that, because there was not a path forward for how to manage this incapacitated gentleman's affairs, there needed to be a guardianship over this gentleman. So when I'm saying an inadequate power of attorney, what I want you to think through and what I want your attorney to think through is it a really good idea to appoint the new wife and the son from the prior marriage as co-attorneys, in fact, to jointly agree and make decision? Well, if they were going to agree, it's not bad, but you have to plan for worst case scenario. And it was pretty obvious in this case that they weren't going to agree. So be aware of who and you're appointing as your attorney, in fact, and don't set up the situation for a failure, which is what happened in that case. So your durable powers of attorney are the most important. I've been focusing on finances more so than anything else, but you do also need a durable power of attorney for healthcare in order to be able to keep control over your life. A durable power of attorney for healthcare is where you appoint the person, your POA, your agent, healthcare agent. Who is that? That's that person who speaks for you and is your voice and will make sure your voice is heard, your wishes are carried out in the event you can't do so. And this doesn't have to be like a dementia type incapacity or stroke. This is maybe you're undergoing surgery and so you're incapacitated and there's going to be questions that come up because of complications during the surgery. Make sure you have that person designated under your durable power of attorney for healthcare that knows you and will be your voice and will speak for you. That's really important to make sure that you keep control over your life. I would say that the other really important estate planning document that will make sure that you keep control over your life is what's called your healthcare directive, called your advance directive. It's called your living will. These all mean the same thing. What is that legal document? It is the document that says that if you meet certain criteria such that you are at end of life. So there has to be this determination. You are at end of life and no reasonable medical treatment is going to make you better. You are in a permanent vegetative condition and you are not going to get better. And your doctors put this into your written record. In the event that all that occurs, such that basically the medical folks have said, there's nothing more we can do. Now, what do you want? Well, you're not in a position likely to speak your voice, so you make sure that your voice is written down in your healthcare directive. And in that document, you'll say, what are your wishes? Do you want heroic measures? If that's your wishes, make sure you write it down. Do you not want heroic measures? Write it down. What are heroic measures? It really depends on the circumstances. I can tell you in my experience with working with clients that, the majority of folks don't want to be kept in a vegetative state. They don't want to be kept alive. If it is, no quality of life, they want to be allowed to pass peacefully and comfortably. So they want pain medication and that sort of thing. If that, regardless of what your wishes are, don't leave it up to somebody assuming you wanted this, or you assuming you wanted that, or you didn't even, they don't know what you want. So they do what they think you want. Put it in writing. That's called your healthcare directive. And the person who will be your voice, who will make sure that your wishes, what you wrote down, will be carried out. That person is called your healthcare agent. That's that person under your durable power of attorney for healthcare. So we all want to keep control of our life. We all want to be in charge until we die. In the event that that doesn't happen, make sure that the next best alternative is that the person that you trust will be your voice, will be carrying out your wishes. There will be no ambiguity. It will be the person you've appointed, and they will be your voice. That is the best way for you to keep control of your life, which I think is probably the most important non-monetary part of having an estate plan. Number 2, promote family harmony. I like to say that an estate plan is one of the biggest gifts you can give to your family. Certainly, you will feel better when you have an estate plan, because you will know that you've done what you must do or should do for estate planning. But the family harmony piece is how that is promoted by a good estate plan is your estate plan is a clear roadmap. It says who is responsible for doing what. I just talked about how your POA, that's the who, is responsible for doing what, for managing your personal affairs, your financial affairs. An estate plan also says who will get what when you have passed away, and who has the responsibility for making sure that your wishes under your will or under your trust are carried out. The person who's responsible is called the executor, or the personal representative, or if it's a trust, the successor trustee. But they will be carrying out and implementing what we call your dispositive wishes. By that I mean what goes under your will or what goes through your trust once you've passed. The roadmap is with clarity, it's without ambiguity. A good estate plan anticipates things that could happen, like, well, what if somebody died? Then who gets it? Your estate plan will say who. So there's not going to be this uncertainty or this, which leads to the potential for arguments and disagreements among your beneficiaries. And ideally, that once you've passed away, your executor will be working with the attorney who prepared your estate plan. That attorney has a lot of information about you, about what your wishes are. And yes, it's clearly set forth in your written estate plan. And your executor doesn't have to go back to that person. But if it was a good estate planning and elder law attorney that you were comfortable with, it usually works well for your executor to go back to that same law firm to help administer your estate. So think about a good estate plan as protecting not just you and your wishes and your family and your money, but very importantly, and to promote family harmony, protecting that person that you've designated to be the responsible person when you can't be the responsible person, either due to incapacity or due to your death. Protect that person. Make sure that they are not going to be subject to attacks by other family members or by beneficiaries of the estate. There are ways that a good estate plan will make sure that you do everything to keep that person safe from attacks. And when I say attack, I'm not talking physical attack. I'm talking about legal attack or emotional attack. Think through, make sure that they are protected. A good estate plan will do that. Let me give you an example. So we're talking about family harmony and promoting family harmony. Everybody's situation is different, and not every family has what we call family harmony. That doesn't mean you don't want to do your best to make it as good as possible. So here's my example. Let's say you are a single person and you have 2 children, one of whom you're very close to and the other you're estranged from. Without an estate plan, your 2 children will inherit equally under the laws of intestacy. And that probably wasn't what you wanted, but you took no action. So that's the result. Let's say that you realize that you don't want your 2 children to inherit equally. So you go to an estate planning and elder law attorney, and they prepare for you a good estate plan. What happens then upon your death? Well, your estate plan said everything goes to the one child. The other child is disinherited. That disinherited child has no grounds for arguing against how the assets are going to be divided because you had a good estate plan. It was not prepared under undue influence. You had an attorney involved who will testify and stand behind your will or your trust, whatever the platform was for you to pass your property on your death, to say, no, this person knew what she was doing and she disinherited this person because they were estranged or whatever the reason is. So by having a good estate plan, you are protecting the person who is carrying out your wishes and protecting the people who are receiving your money from those who might claim it. A couple of tips from things that I've seen in others' estate planning documents. If your will says that let's say your will is set up because you don't want to give one of your children any money, but your lawyer said, let's just put in, I give them $1. That's a really bad idea because by giving them $1, you gave them rights under your will. You see, if you would have said, I disinherit my child, then the only rights that they would have is because they're your child. They are what we call an heir at law. They need to be given notice of the probate, but that's it. They don't have any right to challenge anything unless there's some complicating reason that we're, don't want to squirrel on right now, and that assuming I need to move more, obviously, that, you have a good estate plan, they're not going to have any right to challenge and they have no rights. But if you said, I give them $1, guess what? Now they're entitled to money from your estate. And yeah, you can probably solve it pretty quickly by giving them $1, but then it's best to get a receipt. Anyway, it complicates it, and there's no reason to give anybody $1. And if that child has passed and they left 2 kids, now you've got to, find the grandchildren and give them each 50 cents. So just a tip. If your estate plan, your will says I give them $1, it's time to review it because that was a really bad planning idea. So in order to do your best either to promote and achieve family harmony or keep the person who is maybe the bad apple from causing problems, you can achieve that by having a good estate plan. And part of what we were just talking about is protecting the people who are your decision makers. I think number 3 in one of the benefits of that are not related to, money per se is protect your beneficiaries. Your beneficiaries are the people who receive from you through your estate. And you might be going, what do you mean protect them? Inheritance is usually thought of as a good thing, right? Getting money is generally thought of as a really good thing. You inherit money. But sometimes receipt of money isn't necessarily a good thing. Think about, and I'll give you a couple of examples, like somebody who can't handle money, somebody who's in the throes of a divorce, somebody who owes creditors, somebody who has lifestyle issues, alcohol, drugs, gambling. There's all sorts of reasons that inheriting money outright by your beneficiary might not be a good thing. Protect those beneficiaries. How do you protect them? You protect them by making sure that your will or your trust contains within them protective measures. What do I mean by that? Usually what I'm talking about is a trust. So let me go through some examples. Common problems. You want your children to inherit from you, but you know that one of your children is what the law calls a spendthrift. What that means is somebody who spends money madly, irresponsibly. Interestingly, the term is spendthrift. What do you do? If you know that you have a child that can't control their spending, and it's a big problem, not a little, it's a big problem, then you will include a trust for them in your estate planning documents. So instead of them receiving the money outright when you die, they get it in this protective mechanism called a trust. Let's say that they're not a spendthrift, but they have other lifestyle issues, again, drugs, alcohol, gambling, that sort of thing. Same thing. You put it in their inheritance into a trust. Or let's say that you're concerned that your spouse or that the spouse of your child will divorce them and then they'll get all the money that came from you. Make sure that your child inherits into a trust so that the divorcing spouse gets nothing. Same thing with creditors, other threats. How do you protect your beneficiary? Their inheritance, if they say they have creditors, it's going to go into a trust so that the creditors can't access those funds that came from you that are in the trust. So protecting your beneficiary from themselves or other threats can be accomplished through a good estate plan by the use of trusts, either in your will or in a trust. If you are using a revocable living trust, it doesn't matter. So that's one way to do it. Now, I didn't talk too much about protecting a child who has too much money. That's not as common a situation, but maybe your child is well-to-do and you still want to give them money as opposed to, your money going to other beneficiaries or to charities or whatever the case may be. You can have your child's inheritance, the one that has too much money, go into a particular kind of trust, which doesn't impact their taxable estate. So you're saving taxes for them on their own estate as well. So protect your beneficiaries. That is something that you'll feel good about. Once you do that, you might say, I don't know what to do with this problem. Here's the situation. Your lawyer is going to walk you through this. They're going to tell you what the options are. How do you achieve this result of making sure that the money goes to good use and not where you don't want it to go? There are ways in the law to do that. I've briefly gone over a few of them, but protecting your beneficiaries is definitely something you can do with a good estate plan. So we're talking about our beneficiaries. Often our beneficiaries are our loved ones. And I would be remiss if I didn't talk about protect your pet. Your pet. Sometimes pets are, the nearest and dearest to our hearts. And it is important to think about well, if, I didn't make it home tonight, who's going to take care of my pet? And Washington in particular is open to you creating a trust for your pet. Trusts weren't recognized at what we call common law, but there is a statute. It's RCW 11.118, that chapter, and that talks all about pet trusts. And basically what it says is that the state of Washington will honor a pet trust. So what do? You make sure that you designate who are going to be the beneficiaries of your trust. Typically, it's set up to be the pet that you have now or will have at the time of your death, and it doesn't include any pets that somehow arrive after your death. And you will work with your attorney to determine what's a good amount of money to direct to that trust, and who's the person that's going to be in charge of the money, and who's the person that's going to be in charge of the trust. Oftentimes people, when I say in charge of the trust, I mean in charge of the animal that is the subject of this trust. So let's say you really have a lot of faith and confidence in whomever's going to be the caregiver of your pet. You can make them the trustee in charge of the money too, because you know that they're going to do right by your pet and they're not going to use the money for themselves. Sometimes people have less trust in the financial abilities of the caregiver of their pet and more trust in somebody else with regard to the money. So there'll be a separate person who'll be the trustee. That's the safer route to go, but it's not necessarily always the way that you need to go, dividing out those two functions. The whole idea is make sure that if you want a formal arrangement to make sure that your pet is taken good care of after you're gone, set up a pet trust. I'm not saying that every estate plan needs a pet trust. You can simply, talk to that person or leave written directions about what you expect will happen. And that's what most people do. But I can tell you that pet trusts are not that uncommon. And that's something that your estate planning and elder law attorney can help you set up, because taking care of your pet might be the most important thing to you. Number 5, peace of mind. And I really hesitate to use that term, but frankly, it's true. You get peace of mind. It's overused for sure. Get peace of mind through an estate plan. You'll hear that all the time. And so sometimes it sounds trite, but you know what? There is peace of mind. I can't tell you how many times that once somebody has come in and they've signed their estate plan and they got it done and they feel good. And they say, I feel like this huge weight is off my shoulders because they know that they have a good estate plan and now they don't have to worry about it. So when it comes to an estate plan, just having an estate plan won't necessarily give you peace of mind. If you have an estate plan that you don't understand, you might not have peace of mind because you might be saying, I'm not sure what I have and I don't understand it. I was told it was right for me, but it's too complicated and the lawyer didn't explain it to me, or whatever the reason may be. If you have an estate plan and if you did it yourself, I would think that you don't have peace of mind because frankly, you don't know what you don't know. You don't know what you're doing, and you don't know if your estate plan is right. If your lawyer did it for you, then you are in a much better position. But that's no guarantee that it was the right estate plan for you. And if you have a lot of trust in your lawyer and a lot of confidence, and you just say, I know my lawyer did the right estate plan for me, and I don't have to understand everything about it. I just have so much trust in this person, then great. Then you will have peace of mind. For other people, they need to know more. They need to understand their estate plan. They don't need to know every single word in the document and necessarily what, rule against perpetuities means, or purse derbies, or some of this legal language that you'll see. But they do need to understand how it works. And that is the lawyer's job, to speak in plain language to you, to explain why they recommended the particular estate plan as opposed to a different one, so that you can understand it. Because I believe that it's through understanding what you have and how it works that then you're going to really feel better about it. You're going to say, I don't necessarily understand every little bit of it, but I get the gist. I know how this plan is going to work. It's going to make sure that if I can't speak for myself, then this person will. And that on my death, my assets are going to go to my spouse in this kind of trust, or to my kids in that kind of trust, and that this is the executor. And you know what? More than that, I really feel good about the fact that I know that my attorney who helped me, they and their firm is going to be there to help my family, my decision maker, my executor after my death, or if there's incapacity. They're going to be there to help implement the plan. And there's that continuity of that relationship, so that they feel that somebody's got their back. That's the peace of mind that comes with having a good estate plan done by an attorney that you have a lot of trust and confidence in. So number 5 is peace of mind. You might say, okay, well, how do I find an estate planning and elder law attorney who will help me get that peace of mind? How you will do that. I mentioned earlier that you don't know what you don't know. Estate planning lawyers who don't do elder law, who don't do Medicaid applications and understand government benefits, they too don't know what they don't know. So this is really looking to find some attorney with the experience and the expertise, the skills, and beyond that, the compassion and the caring for their client. The client really matters to them. That's the attorney that you want to find, so that you will have the right estate plan and get the peace of mind that comes with that. So how do you find this person? At ELG Estate Planning, we believe that we fit that profile to help people. We can't help everybody. Obviously, we help people in Washington and Idaho. If you are outside of Washington or Idaho, what do? I recommend that you go online to the National Academy of Elder Law Attorneys. Go to their website, naela.org, and put in your location, and then you'll come up with some names, and then you'll probably want to Google them and see what their reviews say. What does their website look like? How much confidence do you have in them? And then you reach out to them and talk to somebody at their firm, and then you go from there. What's really important is that you get the right fit. Make sure that you feel like that law firm is there to serve you and that they know what they're doing. All right. So I do have some examples about, attorneys that will propose a revocable living trust when it's the wrong situation. So if I have time, I'll get to that. I really want to look at the questions and answers first. One of these is, so let me go ahead and get to the questions and answers. And if I have time, I'll get back and explain how an estate planning lawyer who relies on a revocable living trust all the time can really do a disservice when it comes to a couple in the state of Washington. Here's a question. I'm a Washington resident and U.S. citizen. If I'm worth somewhere around $1 million, I want all my assets, home, investments, to one of my children who is not a U.S. citizen, and he's mentally disabled. Can I assign another of my non-U.S. citizens as legal guardians through a living trust? Fantastic question, and I can't answer that. This is what I can say. Lawyers like to solve problems. How would I solve this problem? I would want to have further information about, well, if your child isn't a U.S. citizen, what country are they a citizen of? And then you partner with the attorney who is in that other country. So I do know enough about Canadian law, for example, to know that Canada doesn't recognize trusts, which is kind of a big surprise, maybe because we're US centric and trusts are a big part of our system. But how would you solve this problem? And a Mexican, thank you. I would partner with an attorney who is in Mexico. And one of the things that I want to say, maybe to simplify matters, is there are attorneys who are both licensed in Mexico and in the US, or in US and in China, or in the US and in France. How do you find that person? Personally, what I typically look for are those really big mega firms that have law offices all throughout the world. That's where I would look to find an attorney who might have licensing in both Mexico and the US, because you know they exist. Let's see. Other questions. We have enough time. I'm going to really quickly go over the revocable living trust before I get to other questions. And recall back, what I'm talking about is an estate planning lawyer doesn't necessarily know what they don't know. And that's true for all of us. I mean, if you're providing a service, you should have expertise, but be clear on where your expertise lies. Mine is in estate planning and elder law with a focus on Medicaid and long-term care benefits. There's a certain area of practice I don't do. Litigation, for example, guardianships. I don't want to be involved with guardianships and conservatorships. So, lawyers typically will have a focus. So an estate planning lawyer that says, a revocable living trust is right for you. You should ask questions. Why is a revocable living trust right for me when I live in the state of Washington? Well, because it avoids probate. All right. What are the benefits? Why am I avoiding probate? Because it costs money. All right. So tell me what it takes to maintain a revocable living trust throughout my lifetime. Doesn't that take money too? Don't I need legal assistance? Oh no, you can do it on your own. How do I know to do it on my own when I don't know what I don't know? That makes no sense. So this is I'm coming to my example on the revocable living trust. So let's take a couple. They're in their 70s. They've been married a long time, and the wife, let's say she has dementia. The husband is good cognitively, but he might be frail. And the attorney, the estate planning attorney, says, let's do a revocable living trust for you, because then on the one death, then the surviving spouse gets it all without the need for a probate. It's really easy, and that's what I recommend. More facts. Let's say that the couple lives in their house together. It's $1 million house. It's paid off. They've got $1 million in investment accounts and bank accounts and such. So they have a $2 million estate. They're not a taxable estate in Washington, and they have a pretty decent sized estate. So what are they concerned about? Well, if you dig in a little bit, you're going to find out, rightfully so, that they're concerned about how they're going to take care of each other. I mean, the husband takes care of the wife and reminds her about her medications and makes sure that she's safe. But what happens if the husband's not there? He's really worried that if he dies first, which is likely because his physical condition is frail, that what's going to happen to his wife? If that's the person's situation, they should not be thinking about a revocable living trust at all. They live in Washington. Their assets are here in Washington. They should be looking at a will that contains an asset protection supplemental needs trust. Why is that? The wife is not going to be able to stay at home, likely, after the husband dies, and the husband likely will die first. She could stay at home, but care in her home is $15,000 to $20,000 a month, and frankly, it's pretty unwieldy to manage a single person's care with dementia in their home through caregivers. That's a big job. So likely she is going to move to some facility, for example, a memory care facility or an adult family home, when her husband passes away first. If they have the right estate plan, that is a will that contains the asset protection trust, and let's just say they've done, that both of them own half of all the assets. When the husband dies first, what would happen? There will be a probate because a will is probated. When somebody dies, there needs to be a probate. What would we do in that probate? We would take the $1 million in liquid assets and we would fund this trust that's contained in the will of the husband who's died. That trust provides benefits for the wife, but she doesn't own the money. She's not in charge of the money. She couldn't be. She has dementia, but even if she didn't, she can't be in charge of it. And that $1 million in that trust is not seen by Medicaid as belonging to the wife, to the surviving spouse. It's not considered her money, even though it's there for her benefit. So through the probate, we take the $1 million of the money, we put it in the trust. The house is put only into the wife's name. She is eligible for Medicaid with $1 million in trust and $1 million house in her name. The house is a non-countable asset. So she qualifies for Medicaid. This is a super simple example. I could get much more complicated and show how we could preserve $2 million, but I'm just keeping it simple. Because what I'm trying to show you is if this couple had a revocable living trust and the $1 million was if they tried to put that into some sort of protection trust for the wife, the state of Washington is going to disregard it. They're going to say, no, that $1 million belongs to the wife. Why? Because the trust for her was created through a revocable living trust and not through a will and a probate. So the wife will need to, without any other types of plans that are in place, will have to spend down her $1 million before she goes on Medicaid. What does that mean? Well, that means that money is going to be spent on her care, whereas it didn't have to be spent on her care. Medicaid would pay for her care if she had a will, if they had the right estate plan. So I am not putting it on this couple that they did anything wrong by getting the wrong estate plan. They simply went to an attorney who didn't know elder law and didn't know Medicaid planning, so recommended a revocable living trust. That in of itself is a reason that you need to ask more questions about the qualifications of the attorney that you're meeting with. All right, let's see. We are not quite the top of the hour, so I'm going to go ahead and wrap it up because I'm not seeing any more questions right now. So if you have more questions, as you probably can tell, we want to make sure that we help people understand estate planning, elder law, Medicaid, long-term care benefits. That's what we do at ELG Estate Planning. And whether you're our client and come see us and we help you personally, or you are simply getting the benefit of the education that comes from watching us online, we want to help educate you to help empower your life goals. At ELG Estate Planning, our phone number is 509-468-0551. Our website is elgwa.com. I am going to go ahead and wrap it up now as we're almost at 1 o'clock. I want to thank you for joining me, and I look forward to seeing you again. Take care. Bye-bye.